Hi, welcome to our YouTube channel. This is MAP, Migration to Asia Peace. Asylum seekers in Korea go through a lot of difficulties due to language barrier and lack of information. MAP's Peace Board project aims to support asylum seekers overcome such difficulties and get on with everyday life and safety, covering 10 crucial topics to know, such as application for refugee status, immigration office, health, education and labor. This series has subtitles in English, Arabic, French, Russian and other languages. Disclaimer: the content is not legal advice. If you have any questions, please contact MAP. In the previous episode, we covered RSD procedure part 1. Today's episode, RSD procedure part 2. If your application is refused and you are not granted the status of humanitarian sojourner, either you can start the next process, the appeal process. You may file an appeal within 30 days of the date you receive the notice of refusal. The date is written at the bottom of the notice. The counting of the filing timeline starts on the day which is counted as day 1, and if the day 30 falls on Saturday or a public holiday, you can file an appeal by the next day. Aside from filing timeline, you should always check your period of stay. If you have 14 days of stay left, you should first complete the appeals process within 14 days and not 30 days and extend your period of stay. When you visit the immigration office to pick up your notice of refusal, a public official may tell you to sign an application for appeal. In that case, do not sign and submit it on spot. You first read the given letter RFRL given with the notice of refusal. We strongly advise you to come up with refuting statements and evidence to boost your chance of success on appeal. Just like an application for refugee status recognition, you can download an appeals application from www.highkorea.ga.kr or use one at the immigration office. Unlike the application for refugee status, there is only one form written in both Korean and English. If you write an appeals application in your first language, you should get it translated into either Korean or English. If possible, attach additional evidence to the application. As with the refugee status application, you can file an appeal at not only the immigration office but also the branch office with jurisdiction over your stay. The refugee committee established under the Ministry of Justice will review your appeal, and it will take 1 year and a half on average to get the result. After the review, it will get the notice of decision by mail or pickup. If you are granted refugee status, you will be issued a certificate of refugee status. If your appeal is denied, you will be issued a notice of denial of appeal and faced with 2 scenarios. One of where you can find one on the bottom of the denial notice that the humanitarian stay permit is granted, although the committee doesn't find your appeal valid. Then you can obtain the status of humanitarian sojourner and change your visa to G1-6. The other is where your appeal is denied without humanitarian stay permit. In this case, you are given a non-permission of extension of period of stay and a notice to leave Korea before your period of stay expires. Unlike RFRL, which is issued for every refused case, a letter stating reasons for denial of appeal is issued for only a few cases. After the appeal is denied, you may file an administrative lawsuit to revoke the decision by the Ministry of Justice. You should do so within 90 days of receipt of the notice. Administrative litigation is based on 3 instance trial systems. For the first trial, the sole administrative court will rule a case in Seoul, and a district court with jurisdiction will hear a case in other regions. A party dissatisfied with the ruling can file an appeal within 14 days. If the appeal filed, the case in Seoul will go to the Seoul High Court, and the case in other regions will be at the district court with jurisdiction. When the appellate decision is issued, a dissatisfied party may file an appeal to the Supreme Court within 14 days. If you lose the final appeal at the Supreme Court, you can reapply for the refugee status at the immigration office within the period of your stay. In this case, you should fill out and submit an application form. For the reapplicants, you can download the form from www.highkorea.go.kr or use one at immigration office. For reapplicants, the Ministry of Justice does not issue residence cards, leaving them within a grace period of departure. You may extend your period of stay by getting a stamp of notification of postponement of the termination of departure, but you still don't have either a G1- visa for asylum seekers or identification issued in Korea. Regardless of which step you are in, you should check your period of stay before your stay expires. You must visit the immigration office or the branch office with jurisdiction over your place of stay. We will talk about how to extend your stay in the next episode. We've so far looked at RSD procedures. Then, what procedural rights are asylum seekers entitled to? First, in the asylum seeker is unable to complete an application form due to illiteracy or disabilities, they can ask help from the public official who receives the application. Both the applicant and the official should sign on all the seal the application form. Second, an asylum seeker can request the Ministry of Justice to have a public official with the same gender interview them. In addition, they can request an interpreter of different nationality or religion. Third, an asylum seeker can request their interview to be recorded either in audio or video format. Fourth, the asylum seeker may request to be accompanied by a trusted person during the interview. For example, they may request to be accompanied by an activist, a lawyer, an interpreter, or close acquaintance. But the refugee screening officer can refuse the request if they believe the trusted person may impair the fairness of the interview. Moreover, asylum seekers with limited influence in Korea may have an interpreter speak for them during the interview. When the interview is over, asylum seekers may ask their interpreter to read out the contents of the refugee interview report to check whether there is an error. They may request an additional deletion or change of the contents, which will be noted in the report in addition to the original record. Lastly, asylum seekers may make a request to read or reproduce the materials they have submitted to the refugee interview report. By filling out and submitting the reading reproduction request form available at immigration office. They can read or reproduce 1. the refugee status application form and evidence they have submitted, and 2. the refugee interview report. However, the request can be restricted if the Ministry of Justice finds there are obvious reasons to believe the fairness of screening is likely to be substantially impaired. please remember these 7 procedural rights entitled to asylum seekers under the Refugee Act. If you have any questions about today's episode, please contact MAP. Migration to the Asia Peace. In the next episode, we will talk about how to use immigration office. Thank you for watching this video.